Court of Appeal of Alberta Form AP5 Rule 14.87. Court of Appeal File Number 2003-0039AC. Trial Court File Number 1903 to 21485. Registry Office, Edmonton. Plaintiff/Applicant, Gerald Key. Status on Appeal, Appellant. Defendant/Respondent, Law Society of Alberta, Attorney General of Alberta, College of Physicians and Surgeons of Alberta. Status on Appeal, Respondents. Document, Factum of the Appellant. Appeal from the decision of the Honorable Associate Chief Justice J.D. Rook dated the 20th day of January, 2020 filed the 20th day of January, 2020. Factum of the Appellant, Gerald Key 144 pages, Form AP5, 2 pages, Table of Contents, 2 pages, Factum, 30 pages, 99 paragraphs, Table of Authorities, 32 pages, Appendix, 78 pages. Gerald Key P.O. Box 29, St. Albert, Alberta, Canada T8N1N9 Telephone, 780-807-8224 Email, Austin Chuai Estate@outlook.com Self-represented litigant. Sharon E. Heine Law Society of Alberta 700 333-11 TH Avenue Calgary, Alberta, Canada T2R1L9 Telephone, 403-229-4753 Email, sharon.heine@lawsociety.of.ca Lawyer for the Law Society of Alberta. Registrar Stamp. Filed August 31, 2020. R.H. Facts alleged against the Court of Queen's Bench of Alberta. For the Court of Queen's Bench of Alberta erred in dismissing the October 18, 2019 originating application for judicial review 50 with the October 15, 2019 fiat to file 3 days late 51 the October 24, 2019 application for production of documents, 52 and the October 24, 2019 application for contempt proceedings 53 without properly examining the evidence provided in the October 25, 2019 affidavit of exhibits 54 nor the facts provided in the October 24, 2019 brief and authorities of the applicant 55 filed by the appellant and served on the respondents on October 29, 2019. Erred in not deciding that the allegation against the appellant by the respondents of an apparently vexatious application or proceeding, pursuant to the Civil Practice Note No. 7, Paragraph 6, Request for Order 56 was the abusive defense tactic and an abuse of the processes of the court improperly designed to bar a valid claim made by the appellant pursuant to the Charter Section 15, erred in failing to properly consider the allegations of the breaches by the respondents of the Charter Section 15, and is properly subjected to the Court of Appeal of Alberta File Number 2003-0039AC. Causes of action against the Court of Queen's Bench of Alberta. 5. The appellant outlines the 2 reasons for why the January 20, 2020 Court of Queen's Bench of Alberta application dismissals were erroneous. 57. A. Whether the Court of Queen's Bench of Alberta erred in not deciding that the allegations by the respondents of an apparently vexatious application or proceeding, pursuant to the Civil Practice Note No. 7, Paragraph 6, was the abusive defense tactic, and an abuse of the processes of the court improperly designed to bar a valid Charter Section 15 claim by the appellant. B. Whether the Court of Queen's Bench of Alberta erred in failing to properly consider the alleged breaches by the respondents of the Charter Section 15, claimed by the appellant. 10. Proceedings below. 6. On January 20, 2020, the Court of Queen's Bench of Alberta erroneously justified the decision not to examine the facts nor the evidence that supports the alleged breaches of the Charter and the contraventions of the Medical Profession Act, the Alberta Human Rights Act, the Criminal Code of Canada, the LSA Code of Conduct, and the Alberta Rules of Court, provided in the brief and authorities of the applicant and the affidavit of exhibits, and to dismiss the originating application for judicial review with the fiat to file 3 days late, the application for contempt proceedings, and the application for production of documents, and based that decision upon 58a, the Court of Queen's Bench of Alberta being notified of an allegation of an apparently vexatious application or proceeding, per Civil Practice Note Number 7, Paragraph 6, b, the review by the Court of Queen's Bench of Alberta of that apparently vexatious application or proceeding allegation, and the conclusion that the alleged apparently vexatious application or proceeding exhibited the indicia of an abuse of litigation and appeared to be an abuse of the processes of the court. Part 4, Argument. Ground of Appeal Number 1. The Court of Queen's Bench of Alberta erred in not deciding that the allegation by the respondents of an apparently vexatious application or proceeding, pursuant to the Civil Practice Note Number 7, Paragraph 6, Request for Order, was the abuse of defense tactic, and an abuse of the processes of the court improperly designed to bar a valid Canadian Charter of Rights and Freedoms Section 15, Equality before and under law and equal protection and benefit of law. Claim by the appellant. 9. In the December 12, 2019 written response of the appellant at paragraph 42, that stated 62. 10. In the December 2, 2019 Court of Queen's Bench of Alberta Memorandum of Decision at paragraph 17,63 the Honourable Associate Chief Justice J.D. Rook mentioned the expressed prohibition of the close call, but made no mention in the January 20, 2020 application dismissals of the allegation by the appellant that the Civil Practice Note Number 7, paragraph 6, invoked by the respondents against him, was the abuse of process abused for the close call. The appellant referenced the December 2, 2019 Court of Queen's Bench of Alberta Memorandum of Decision 64 and our jurisprudence provided in UNRAW v. National Dental Examining Board, 2018, at paragraph 22, 65 that provided the expressed prohibition that the Civil Practice Note Number 7, paragraph 6, was not to be abused for the close call. Although the appellant is unable to identify the precise definition of a close call, he interprets that to indicate an unfavorable situation for a defendant who is without any valid defense, combined with a favorable situation for a plaintiff who, with an allegation that is supported by the facts and the evidence with the substantial merit, has approached the court in the public interest to seek an answer on a question of law. Furthermore, the applications by the appellant were not the clearer cases of abuse, nor were there any significant defects or defects in question that were apparent on the face of the pleading for the court to reasonably justify, pursuant to the Civil Practice Note Number 7, paragraph 2, order to stay, dismiss application or proceeding 66 the stay of proceedings, nor the application dismissals, without examining the facts nor the evidence. 13. 11. The respondents have no valid defense for the allegations by the appellant. They are stuck in the corner, about to be pinned to the wall, unable to produce a Charter Section 1 justification within the reasonable limits prescribed by law as could be demonstrably justified in a free and democratic society for the alleged Charter Section 15 breach 67 and unable to provide a rebuttal in their uphill battle to explain the spoliation of evidence. Therefore, the respondents have resorted to the sneaky tactic of abusing the Civil Practice Note Number 7, paragraph 6, in order to prevent the court from examining the facts and evidence in order to defeat the allegations of the Charter Section 15 breach, conspiracy, malicious prosecution, defamation, spoliation of evidence, and bias, etc., committed by the public officials in the province of Alberta, and to continue with their undeterred efforts to obstruct the access to the court by the appellant, and to suppress the truth about what they did to him and to A.J. Arkey. 12. In the December 12, 2019 written response of the appellant at paragraph 6, that stated 68. The appellant articulated to the Court of Queen's Bench of Alberta that the respondents have employed the sneaky tactics in order to discriminate against him and A.J. Arkey, have harmed the members of the public, are a continued danger to the public whom they profess to serve, and remain undeterred from that misconduct. However, the court disregarded that articulation by the appellant, provided no further commentary on the close call, and exercised the inadequate examination or consideration of the alleged Charter Section 15 breaches, the facts, and the evidence, and did not consider the legal duty of the court to deter such misconduct and to protect the vulnerable citizens from the discrimination by the government officials. 13. In the January 20, 2020 Court of Queen's Bench of Alberta application dismissals at paragraph 8, that stated 69. 14. In the December 19, 2019 LSA written reply at page 1, that stated 70. The chicanery of invoking the Civil Practice Note number 7, paragraph 6, abused by the respondents for the close call, in order to cause the Court of Queen's Bench of Alberta to disregard the facts and the evidence provided by the appellant in the brief and authorities of the applicant and the affidavit of exhibits, relating to the alleged contraventions and breaches by the respondents, ineptly cited our jurisprudence provided in Devine v. Alberta Supports, 2019, 71A and A. Statutory provision of the Alberta Rules of Court Rule 3.68, 3, Court options to deal. 14. With significant deficiencies. 71B. That was the unscrupulous attempt by the respondents to negatively categorize the case of the appellant with another case with the substantial differences. 15. In Key v. LSA, Attorney General of Alberta, and CPSA, 2020, the appellant invites the Court of Appeal of Alberta to correct the error made by the Court of Queen's Bench of Alberta to disregard the evidence to support the fact that the CPSA and L.R. Althauser contravened the Medical Profession Act, the Alberta Human Rights Act, and the Criminal Code of Canada, that the CPSA breached the Charter Section 15 Equality Rights of AJR Key, that S.J. Bike which contravened the LSA Code of Conduct, the Alberta Rules of Court, and the Criminal Code of Canada, that the Attorney General of Alberta and the LSA breached the Charter Section 15 against him, and that the respondents abused the Civil Practice Note number 7, paragraph 6, for a close call. Key and Devine are considerably different except for the similarity that those both involved the public officials who invoked the Civil Practice Note number 7, paragraph 6, for their defense. 16 at page 2, that stated 72A. The appellant contends that position by the LSA, supported by the Court of Queen's Bench of Alberta, that the same conclusion may be drawn in Key as in Devine, for the reason that the questions of law in Devine are significantly different than the questions of law in Key. Although some of the respondents in Devine are the government officials, K. Devine makes no invocation of the Charter Section 15 nor Section 24. Instead, he invokes Section 7 without citing the statutory provisions nor the jurisprudence to support his argument. 72b. However, in Key, the appellant contextualizes the breaches of the Charter Section 15 Equality Rights and the contraventions by the respondents, supported by the statutory provisions and our jurisprudence. 17. The abuse of invocation of the Civil Practice Note number 7, paragraph 6, by the respondents to defeat an alleged Charter Section 15 breach could not be reasonably supported. The Charter is the constitutional law, superior to the other legislation in Canada. That is not tenable that the respondents could abusively invoke the Civil Practice Note number 7, paragraph 6, to defeat a valid and highly contextualized Charter Section 15 breach allegation by causing the court not to properly examine the facts nor the evidence to support the allegations. The facts and the evidence that supports the alleged Charter Section 15 breach were contextualized and provided in the brief and authorities of the applicant and the affidavit of 15 exhibits. However, the abuse by the respondents of the Civil Practice Note number 7, paragraph 6, caused the Court of Queen's Bench of Alberta to disregard the facts and the evidence in those documents, thus maliciously instigating the erroneous January 20, 2020 Court of Queen's Bench of Alberta application dismissals, and the Charter Section 15 claim dismissal. 18. In the December 12, 2019 written response by the appellant at paragraph 44, that stated 73. 19 at paragraph 15, that stated 74. That was the malicious threat made in bad faith that, even if the appellant was to provide the beyond a reasonable doubt evidence to the Provincial Court of Alberta that would likely result in a conviction, in addition to the relevant public interest factors, and the judge issued process for the indictment and the summons against the CPSA or LR Allhauser, the agent of the Attorney General would order the stay of proceedings against the accused in any event. 20 On September 10, 2015, in the Provincial Court of Alberta, the Honourable Justice Mallin stated 75. 21 He also stated 76. 22 The respondents have exhibited the history of the malice and the abuse of process. On January 15, 2020, in the Court of Queen's Bench of Alberta, the appellant stated 77. 23 On June 18, 2020, the Chief Justice of Canada, the Honourable R. Wagner, addressed the citizens of Canada in the Supreme Court of Canada Annual News Conference. The Honourable Chief Justice of Canada stated 78. 24 In the January 20, 2020 Court of Queen's Bench of Alberta application dismissals, the case was not decided upon the evidence that was brought before the court. Rather, as a result of the malicious abuse by the respondents of the Civil Practice Note No. 7, Paragraph 6, the Honourable Associate Chief Justice J.D. Rook was deceived with the mischievous citations from Divine and the Alberta Rules of Court Rule 3.68.3, into not properly examining the facts nor the evidence provided by the appellant in the brief and authorities of the applicant and the affidavit of exhibits. As a result of that abusive defense tactic where the respondents instigated the stay of proceedings against themselves, the Honourable Associate Chief Justice J.D. Rook was deceived into not acting according to his judicial duty, and did not properly recognize the evidence that was brought before him. Therefore, he did not recognize the Charter Section 15.16 breach by the respondents, and was unable to uphold that constitutional provision, nor provide the appellant with the equal treatment under the Canadian law, nor denounce that discrimination, nor even provide the proper remedy. The appellant invites the Court of Appeal of Alberta to examine the facts and the evidence provided in the extracts of key evidence, and the facts and argument provided in the factum, with respect to the statutory provisions and our jurisprudence provided in the Book of Authorities, in order to recognize that the respondents have abused the Civil Practice Note No. 7, Paragraph 6, and have discriminated against him and A.J. Arkey, and with respect to the Charter Section 24. Enforcement, provide the responsive and meaningful remedies for those breaches of the Charter Section 15 equality rights. Ground of Appeal No. 2, the Court of Queen's Bench of Alberta erred in failing to properly consider the allegations of the breaches by the respondents of the Canadian Charter of Rights and Freedoms Section 15, equality before and under law and equal protection and benefit of law, claimed by the appellant. 99 The relief sought by the appellant against the respondents include: A. Certiorari. A. The appellant seeks the certiorari in the judicial review to quash the illegitimate April 11, 2019 LSA appeal dismissal. B. The appellant seeks the certiorari in the appeal to quash the erroneous January 20, 2020 Court of Queen's Bench of Alberta application dismissals.